Guardian ad litem fees in an Illinois divorce. A family's dynamics can be too tangled for a judge to unravel, especially when parents disagree about custody or support. In such cases, Illinois courts may appoint a guardian ad litem, or GAL, to investigate, report and make recommendations for the child's best interests. This neutral lawyer gives the court an objective perspective and ensures that a child's voice is considered. While the GAL's purpose is clear, many people wonder who pays the bill. A guardian ad litem is an attorney appointed under 750 ILCS 5506 to assist the court in any matter involving support, custody, visitation or other welfare of a minor. Once appointed, the judge must issue an order addressing costs and may require a retainer. In practice, the initial payment is often around $2,500 and typically split evenly between the parties, although the court can later reallocate costs. If one parent controls the household income and assets, that person may be asked to pay the initial retainer, but allocation can still change later. The GAL must provide detailed invoices within 90 days and every 90 days thereafter, and courts review those invoices to ensure fees are reasonable. Even when invoices are late, courts have held that the statute's requirement is directive, not mandatory, so a GAL can still collect fees. Allocation of fees. Illinois law grants wide discretion to decide who pays the guardian ad litem. The trial judge can require either or both parents, another party or the marital or child's estate to pay. Courts apply the same principles they use for interim attorneys' fees, looking at each party's income, property, needs, earning capacity and the standard of living during the marriage. Judges also consider the complexity of the issues and other equitable factors, the skill and standing of the lawyer, the difficulty and importance of the case, and customary charges. In practice, judges focus on disparities in the parent's ability to pay. When one spouse has a much greater financial capacity, that spouse may be ordered to cover most of the fees. Courts may also make the party whose conduct necessitated the GAL's appointment bear more of the cost. There is no fixed cap. Fees must simply be reasonable, and they may continue even after a GAL withdraws if work continues. Other considerations. Because a guardian ad litem lacks a paying client, the system makes it difficult to avoid paying. Once appointed, you cannot easily stop a GAL from billing without reaching an agreement with the other parent. Challenging fees is only possible when the GAL fails to show what work was performed. Even then, an appellate court may let the GAL return to prove services and get paid. Fee orders can be appealed only for an abuse of discretion, and they are rarely considered final. Sometimes a judge appoints a psychiatrist or mental health professional instead of, or in addition to, a GAL. The court can order these costs to be paid by one or more parties and later redistribute them. If you request an evaluation that is not adopted as the court's witness, you will generally pay the entire fee unless the judge decides otherwise. Bankruptcy and non-dischargeability. Divorce often leads to financial strain, but guardian ad litem fees cannot simply be wiped away. Illinois law treats GAL fees as domestic support obligations, meaning they fall within the exceptions to discharge under federal bankruptcy law. Courts have held that attorney fees connected to custody and support issues, including GAL fees, are non-dischargeable. This policy exists because unpaid fees would discourage lawyers from serving as GALs and undermine the court's ability to protect children. Contested divorces are expensive, but time with a child cannot be regained. Having a clear understanding of which expenses are worthwhile and which battles to avoid is important. This discussion was prepared by the law office of Russell D. Knight, an Illinois divorce law firm. Russell D. Knight is an Illinois divorce attorney who has authored numerous articles on family law and offers courtroom-ready advocacy at his Chicago law firm. For personalized guidance on who pays a guardian ad litem, contact the law office of Russell D. Knight at 1165 North Clark Street, No. 700, Chicago, Illinois, 60610-773-334-6311.